Hey good people, welcome back to my YouTube channel Beyond the Brief, where I demystify part 2 of our legal drafting series, the prayer clause. Many cases fail not on facts or law, but on the last paragraph. Imagine a judge agreeing with your facts and your analysis of the law, but still does not grant you the reliefs or the prayer sought. This is not because your case is weak, but probably because your prayers are defective. I want you to remember this. The prayer clause is not a wish list. It's the logical conclusion of your pleadings. A lawyer may ask, should the prayer clause have reasons? And the answer is, the prayer clause is not the place where you argue your case. It shouldn't have a narration of your facts, the evidence, or emotional language. However, it must state briefly the legal footing on which the reliefs are sought. For example, if your prayer clause says, declare the transfer instrument null and void, then the court may ask itself why. Your prayer should be, declare the transfer instrument dated such and such a date, null and void, having been executed during the subsistence of an injunction. Then in that way, the court understands the basis for granting the reliefs sought. That is clarity, not arguments. Lawyers always have this prayer in their pleadings. Any other relief that the Honorable Court may deem fit to grant. Well, that is a prayer, but it cannot stand on its own. It's not a substantive prayer, and it can only act as an auxiliary or a consequential relief flowing from a specifically pleaded substantive relief. On its own, it cannot cure a defective prayer. Another common mistake is contradictory prayers. You cannot seek specific performance, say for a defendant to complete the sale of land, and also you seek rescission of the sale agreement or the contract and refund of the purchase price. This is so because you can't seek to enforce a contract and cancel it at the same time. It can only be either. Prayer clauses must be proportionate. If you go overboard with your prayers, there is a high possibility that you're going to encounter a lot of resistance from the defense. Targeted reliefs will always invite the court's consideration. And remember, your reliefs must stem directly from your pleadings. If you want to draft just like the courts expect you and not how templates teach you, please subscribe to my YouTube channel, Beyond the Brief. Thank you.